Hi, welcome back everybody to our afternoon session of environmental training. We're going to take some time this afternoon to answer a couple of questions that have come up while we were at lunch, and also to introduce some new members of our panel. If you don't remember, my name is Laura Myers. I am the Field Environmental Officer for Region 6. And then Rick Shaw is here, and our new people are...
Barbara, go ahead.
I'm Barbara Britton. I'm the Director of the Environmental Review Division in the Office of Environment. I used to be the Regional Environmental Officer in Region 6, so hello to Region 6.
And I'm Nancy Boone. I'm the Federal Preservation Officer for the department.
Okay, we got a couple of questions that came up. One was whether or not a field environmental officer or regional environmental officer needed to review and sign off on a categorically excluded project, a 223F project. The answer is no. Only the 221D4s or new construction environmental assessment level projects require the field environmental officer to sign off if they are over 200 units. And I believe there was an asbestos question. I don't see it up, but maybe you can.
Yes, from memory, there was a question as to whether we can ever waive asbestos, and why would we? And this simple answer would be that if, as an example, if we had a seniors project and the asbestos was only in the elevator room maintenance area that could be locked off, where if we did abatement and removal, the elevators in a senior building would be shut down for upwards of 4 to 6 weeks for the removal process. We would consider a waiver in that case. It would be part of the O&M plan. Maintenance staff would be aware of the asbestos and would be notifying any contractors and outside workers as to where it was and what its status was. And we'd have an updated status report on a yearly basis, and probably a 5-year review as well, to be monitored by HUD staff on the asset management side. So that takes care of that. I think we're going to go into contamination and toxic substances with Barbara Britton.
Feel free to ask us questions as they come up, and we'll get to them at the end of the segments.
Okay, I'm going to provide you with an overview of our contamination policy, Part 50.3I and 50.4I, and Chapter 9 of the MAP Guide. I want to say that this area of environmental review is one of the most technical areas that we have to deal with. It often involves a level of high-end expertise in environmental science and engineering, and it's not something that usually can be addressed by just one person. You normally would have to have a team of people involved in really extensive site contamination issues. So HUD site contamination policy is that all properties for use in HUD programs be free of hazardous materials, contamination, toxic substances, gases, radioactive substances where the hazard could affect the health and safety of the intended occupants or affect the intended use of the property. And our goal here is to protect the health and safety of our HUD assistants, people who receive HUD assistance, and the utilization of the property that we plan to use it for. In the multifamily housing context, the contamination standard applies to all housing projects except for 223A7, which is categorically excluded, not subject to. Many people often ask us, why do we need to worry about contamination? One of the major reason is that we need to make sure the occupants and users of HUD assistance are safe. We also need to make sure that the project itself is viable. We want to make sure that site contamination doesn't affect property values, that the borrower's ability to repay a loan isn't affected by a site contamination that wasn't identified before HUD issued the loan. And we want to make sure that HUD doesn't suffer financial risk from foreclosures. So again, the aim of our site contamination policy is to protect people, both their health and quality of life, and to protect the investment, property values, and also limiting business environmental risks to HUD. Many of you may be familiar with the Love Canal example. This is one of the early cases of extensive site contamination that was covered in the press I know when I went to work at EPA in the early 1980s, this was a really big deal. In this case, a housing development had been put on a place where the Hooker Chemical Corporation had operated since the 1949, and they were producing chemicals, storing the chemicals in containers, and put it in a canal. That's why it's called Love Canal. The canal was buried, covered over with dirt, and was later leased to the school board, and the housing site was developed on that as well as schools and other infrastructure. As time went on, the occupants of the housing noticed cancer cluster in the area, found that the site was contaminated not only with vapors coming up through basements, but actual chemicals were coming up through basements of people's homes. The cleanup of this site was extensive. It involved more than 900 families. HUD supported the relocation of those families. The cost of remediation was over $400 million. It took 21 years to complete. And Occidental Chemical Corporation, who bought the property later and was one of the previous owners, paid $129 million to cover the cost. Another example is the Brio Superfund site in Harris County, Texas. The map on the left, you can see a lot of vacant land there. That used to be a residential housing area that included 677 residential housing units. There was a lot of FHA involvement in this site that had been located adjacent to a chemical reprocessing plant and a refinery. Again, the residents noticed health effects in their neighborhood, and it was investigated in 1986. EPA listed this site as a National Priorities List site. Basically, people walked away from their homes. There was a huge litigation, and I think it was in 1986, there was 1992, there was settlement of one of the highest, most costly damage settlements in history of $207 million that the developer and 6 chemical companies had to pay. EPA was really never able to remediate the site because of the cost of it, and so basically the site is contained, areas of it are capped, it's fenced off, and as you can see, it's now vacant land. Environmental liability is something that comes to mind with site contamination. We have National Environmental Policy Act liability. HUD, if you don't comply with site contamination in the proper way and you miss something during the environmental review process, there can be litigation against HUD and on the Part 50 review, and HUD would have to go back and improve its environmental review, which is the least of our worries. If, for example, we don't evaluate a site thoroughly and we happen to allow a project that has site contamination that involves low-income and minority populations, we can end up with a Title VI complaint. And we can also be subject to court-awarded damages for health, loss of income, loss of property values, much like the South Bend neighborhood case. And then there's cleanup liability. Even if EPA doesn't come after the property owner for cleanup under Superfund, if a property owner acquires a contaminated site without properly evaluating for contamination, and the site is later found to be contaminated, they have to clean it up. So either it just has to sit there, or they have to come up with the money to clean it up, and the cleanup costs typically are in the millions of dollars. So the contamination sources that we are normally concerned with are landfills, buried waste, as in the case of Love Canals. Underground storage tanks are a big source of contamination. Those are largely unseen and underground, so you don't know until you test. The upper right corner is a pile of mine tailings, which are very toxic. The pile itself looks very innocuous, but it's not. So that's something that we have to look for when we're evaluating for site contamination. Vapor encroachment is one of the biggest issues that we're concerned with housing. This occurs when there's contamination in land or soil or groundwater beneath housing, and that vaporizes into the houses, into the basements and crawl spaces, and it causes a serious means of exposure to toxic substances. The most common sources of vapor intrusion for residential properties are former and present gas stations and dry cleaners. These sometimes seem like small ma and pa shops, but they can pose a big risk for site contamination. We're also find that proximity to dumps, landfills, and current and former industrial sites and former manufactured gas plants can also pose contamination risk to residential properties. People are exposed to contamination through soil, through groundwater, surface water, air, and you can ingest contamination, you can inhale it, and you can absorb contamination through your skin. So in the example, the playground example there, if there's contamination in that area, the children can absorb contamination through their skin, or they can ingest contaminated soil. And if it's in the air, they can ingest the soil. Ingest the air pollution.
Inhale.
Sorry about that. So just a little background on the legal and regulatory overview. There are two major laws that govern site contamination at the federal level. The first is the Superfund law, known as the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA. It was enacted in 1970 in response largely to site contamination issues like Canal. It's the primary program for cleaning up the nation's abandoned contamination sites. This is where an owner of a property goes bankrupt and the operation is no longer viable. And actions of the Superfund program are triggered by a release or threat of release of hazardous substances, which you will hear more about. Under Superfund, in 1986, an amendment was passed to allow for landowner liability protections. This is so that people purchasing properties had a way of not being liable for cleanup if they purchase a property that's contaminated. There are three types of landowner liability defenses, and the way you avail of these protections is to prepare an ASTM Phase 1. What's important for FHA and any federal agency to be mindful of, if a housing property reverts to HUD and HUD owns the title, we are not eligible for the landowner liability protections. If we have title to a property that's contaminated, HUD has to clean that property up before it can dispose of it. And so this is why the multifamily program, FHA in general, is very careful about site contamination issues for properties that it insures. The second major law, a federal law that we're concerned with, is the Resource Conservation and Recovery Act. It was enacted in 1976. This law covers properties that are currently owned and operated and have an owner that hasn't walked away. It governs the control of hazardous waste from cradle to grave, meaning from generation to transport, disposal. So it tries to prohibit any kind of contamination for now and into the future. One of the things that's very important to keep in mind as we're doing HUD environmental reviews for site contamination is that this always involves regulatory oversight. We use local, state, tribal, and federal laws to govern how we meet our site contamination standards. If a site is contaminated, we have to turn to the local, state, tribal, and federal regulatory oversight agencies. They are the ones who establish the contamination criteria and standards, and they provide for regulatory oversight of any type of cleanup that might be necessary. HUD has specific requirements in Part 50 for site evaluation. It requires that any proposed site be evaluated to determine if it's in the proximity of dumps, landfills, industrial sites, or other locations that may have contained or have contained contaminated substances. We need to evaluate previous uses of the site if it's a multifamily or non-residential project to ensure there's no evidence of contamination. And we need to apply current techniques used by qualified environmental professionals. Multifamily housing is really fortunate to have the MAP guide in Chapter 9, and in particular, sections 9.2 and 9.4 on site contamination. These sections spell out in detail how to meet HUD site contamination policy. Just kind of an overview of the things that you need to do when you're doing an environmental review and applying the MAP guide requirements. The HUD staff looking at the application must independently review the Phase 1 and Phase 2 studies that will be submitted with the application. Also, the MAP guide requires that HUD staff conduct a site visit and review the Phase 1 and Phase 2 prior to the site visit to make sure that you can confirm or refute what the applicant has provided in the Phase 1 or Phase 2. When there are issues identified in the review process, initial review process, it's best to bring technical support in early on when concerns are identified. Also, in complying with the MAP guide, you need to ensure proper documentation for environmental review and make sure that all project conditions are identified throughout the process and that they're conveyed in loan closing documentation. So we'll review briefly the steps in reviewing for compliance for contamination. These are the 9 steps. The first is to identify whether there's a likely presence or presence of hazardous substance or petroleum products. The second step is to confirm the presence if you've identified a concern. The third step is the HUD site visit. The fourth step is to complete full site characterization of site contamination if something has been identified. And then we go from there. If you've confirmed contamination that needs to be remediated, you need to complete a remediation plan, go through the remedial action process, obtain the site closure documentation, and enter your review in HEROES, and then convey the requirements during closing. And we'll go through each of these steps briefly. So step 1 is to determine the presence or likely presence of contamination. I think Dan alluded to this morning, most of the Phase 1s that we see don't elicit a site contamination problem, but there are cases where they do. So we'll walk through all those steps. So again, the ASTM Phase 1 environmental site assessment is the first thing that we look at. It requires that the ASTM standard requires that this be prepared by a qualified environmental professional. This study does not involve environmental sampling at all. We're simply looking at records, and the EP conducts interviews and conducts a site visit. One thing to note, and I think this has been pointed out earlier, that the Phase 1 ASTM is not an environmental site assessment, environmental assessment, so please don't get those confused. So really what we're after here is to determine whether there's the presence or likely presence of hazardous substance or petroleum products, and if so, this is called a recognized environmental condition. The use of the Phase 1 for HUD site contamination evaluations is a little bit different than it normally would be when someone is using them to become eligible for the CERCLA landowner liability protections. While those liability protections are important certainly for the property owner and for the lender, again, if HUD holds title to the property, then we aren't able to use those liability protections. We're more interested in complying with 24 CFR Part 53.3I, our site contamination standard, and limiting environmental risk. So our focus is a bit different. There are some additional MAP requirements, MAP guide requirements that apply on top of what the ASTM standard applies. For the Phase 1, HUD has to be designated as an authorized user. The Phase 1 has to be conducted within 1 year of application to HUD for an FHA mortgage. The Phase 1 has to require full disclosure of any previous or ongoing remediation at the site. And it also requires, HUD also requires a vapor encroachment screen. This used to be more difficult than it is now. The new standard, 2013 standard, requires vapor encroachment screen in the Phase 1, so that's automatically completed with those. This is an outline of the Phase 1 contents. It includes a summary, introduction, the user-provided information, records review, site reconnaissance, interviews, and then the evaluations that includes the findings, opinions, and conclusion. This is where the environmental professional talks about any wrecks that were identified and the data gaps that might have prevented the EP from finding wrecks. It can also include non-scope items, although we really prefer to see those in a separate report, and then appendices. The first thing that the EP does when they're conducting Phase 1 is to conduct a records review, and this is really looking at all the state, federal, and tribal environmental records. You'll see brownfield sites, Superfund sites, RCRA sites. I mean, it just includes a lot of information in the databases that are available for conducting these kinds of searches. And then we look at once those sites are identified, then we look at the search distance from the property to the site. The All Appropriate Inquiry Rule, which drives the ASTM standards, details minimum search distance requirements for each property. This is a summary of those. For the most part, we want to look at any Superfund site or RCRA corrective action site that's within 1 mile of the property. If the property, we look at whether the property has institutional controls or engineering controls, which are indicative of a previous cleanup at the site, and we're really only looking at the property that we're concerned with. And any kind of activity that involved an emergency response notification, we look at that specifically to the property. If there's a RCRA generator near the property, we consider the property itself and the adjoining property, and registered storage tanks on the property or adjacent to the property. For everything else, we're looking at half a mile out from the property. This may be a little bit hard to see, but this is a summary sheet of a government record search for a Phase 1. You can see that there are a number of hits on this page that indicate that the property is within the minimum search distance for a number of sites that we might be concerned with. Normally, when I see something like this that has a lot of hits within the minimum search distance, I want to take a harder look at this. If you're an underwriter and you're considering an application like this, if I saw that many sites, I would recommend that you refer that to technical support immediately. It might be fine. The environmental professional might have been able to rule out contamination for all these sites on this page that have a red arrow next to them, but that is something that someone with specialized expertise would need to take a look at. There are things called activity and use limitations in the ASTM standard. These can be really important. They are indicative of a past or present release of hazardous substance to the property. There might be land use controls to restrict access to contaminated areas. There might be engineering controls to prevent exposure to on-site contamination. And there might be environmental liens where that's like any other lien. Somebody wants the owner to pay for a previous environmental cleanup. So you need to be mindful of those kinds of issues that come up. And these are found in recorded titles, deeds, and judicial records. One of the things that the ASTM standard mentions is that these are not always, looking for these kinds of records and issues is not always automatically in the scope of the environmental professional for the Phase 1, but they're very important. So I hope that multifamily has a way of looking for these. It might be done through the title search, I'm not sure, but it's important to look for these kinds of issues. Historical uses is another thing that's very important and is mentioned in our site contamination policy. People need to look back at what the site was used for, and the reason we do that is because sometimes people may not know when they're buying a property that it was the site of a petroleum tank farm, or had there been a photo lab there, or a gas station, or dry cleaner. So we want to look back at the records to see what was there before. And some of the records that we typically look at are Sanborn fire insurance maps, property tax records, city directories, chain of title, aerial photographs. On Google Earth has a historic function on it, and you can scroll back and look at time. Some areas have this where you can look back 20 or 30 years on Google Earth, but you need to look at building and zoning and planning records and other sources. So what we're typically looking for when we look at historic uses, again, are the present and former gas stations and dry cleaners, landfills, former industrial facilities, underground heating tanks, naturally occurring asbestos. One of the things that should be of interest for housing is whether a property has been used as a meth lab, because that can really leave some very nasty contamination on site. We look at petroleum refining and storage facilities. We also need to look at whether there have been former military bases or bombing ranges. We've had a couple of cases here at HUD where we found properties located on formerly used defense sites, just something that we hadn't really been concerned with before or seen before, but that's been an issue of late. You need to look for former agricultural operations where pesticides might have been used. Auto dealerships and repair shops could be an important use that contaminated the property. So if you see anything of these things, if you doing the initial review on the phase one, then you need to flag that to talk to technical support about it. So the environmental professional will also conduct interviews with past and present owners, occupants, and neighbors, and they'll also speak to state and government or local officials. You need to refer any phase one to technical support if the interviews elicit that the property has been previously contaminated, had any violations or spills or releases, if there are any active or abandoned storage tanks or leaking underground storage tanks, any kind of illegal dumping, or just anything that an interviewee might identify that could indicate there's been contamination to the property. The phase one environmental site assessment also requires site reconnaissance. And the reason a site visit is really necessary, there are just some things that don't show up in government records. And an interviewee might not tell you about things, so things that you can't see from the other sources are things like unpermitted industrial facilities. Those are not going to show up in government records. Mounds, distressed vegetation, and empty chemical containers are things that you can't see any other way than to go on site. So these are some potential recognized environmental conditions that an environmental professional might identify in a site visit. Vent pipes, like the vent pipe on the right, that's connected to a huge underground storage tank. It might look innocuous on the surface, but can be a significant source of contamination. And the bottom left are chemical containers, and that's usually indicative of on-site contamination. And it's something that if a site visit, the EP identifies these kinds of things for a site visit, you need to refer this to technical support. So just in looking at the phase one, if you're not satisfied with the results, or something, you have questions, or something doesn't make sense, refer to technical support or ask your program environmental clearance officer. You need to ask questions. I mean, when you're reviewing these things, you're looking after HUD's best interests, you're looking at after the best interests of the occupants of the property. So, and it's much better to ask questions now than to find out that something happened later. So the second step, if the phase one indicates a wreck, or if there, for some reason, HUD looks at the phase one and maybe there's no wreck, but there's something that concerns us, HUD can require an ASTM phase two. This is actually where we go out and sample the property to determine whether a wreck is present or not. And normally, if a wreck has been identified in a phase one, it would automatically, the applicant would automatically submit a phase two. And this should be submitted at pre-app, or if there is no pre-app, it should be submitted at firm. I would say that any application that comes in with a phase two should be referred to technical support. Phase twos are scientifically based evaluations of site contamination. They're objective, representative, reproducible, and defensible. They have an objective and scope. They have a sampling plan, sampling and analysis plan, and they have to validate a conceptual model. So it's not a casual thing. I mean, this is a very rigid process that is necessary for phase two. So if you get through the phase two process, it can either rule out site contamination. If you thought something was there, it turned out wasn't, then that's good. But again, you need to confirm that with technical support. On the other hand, if the phase two does confirm the presence of site contamination, then you need to go on to the next steps. Sorry, I skipped a step myself. So you've got the phase one and phase two. You need to do this HUD site visit. This is different than the phase one site visit. This is where HUD staff actually go to the site and confirm the results of the phase one and phase two. You need to look at the project site and neighboring properties and the structures and take notes and compare and contrast with the phase one and phase two. Before you go out, you need to prepare yourself, make sure you've got a Google Earth map that you can refer to so you can see the property, what's around it, and just familiarize your site to the extent possible before you go on site. Until just recently, multifamily housing used the sample field notes checklist to kind of guide the site visit. I think now, I'm not sure if that's still in use, but OEE has a site reconnaissance checklist on its website that can be used, and this is an example of that. What the checklist does, it just guides you through the steps and identifies the things that you need to be looking for. When you're on a site visit, you need to make sure that you go through the whole site. If the doors are closed, you might want to open them. If there's a bunch of stuff laying around that doesn't smell good or feel good or, kind of makes you feel uncomfortable, you need to take note of that, ask some questions of what was in those containers and when did they spill, how long has that spill been there, and could what spilled out possibly have gone down the drain. So, and that drain there is a source of contamination, underground contamination. It could be in the groundwater underneath the property. So after you've reviewed the phase one and phase two and walked the site, you need to determine if the project complies with the site contamination standards. If all the requirements are met, the phase one didn't identify a problem, the phase two was conducted, it didn't confirm contamination, then compliance is complete. But if contamination was confirmed, then you need to go on to the next steps. Again, this is the point at which things can get very technical and complicated. Technical support would always need to be involved in this stage. So the fourth step is completing the site characterization report. Under the phase two, there was some sampling that was done that in areas where if there was contamination, this would be the place where contamination would be the most likely to occur. Site characterization is where you go out and look at the whole site and determine the nature, extent, and magnitude of the site. You want to know how far the contamination spread out on the surface of the property and how deep it goes. The site characterization report, again, is very technical. It uses scientific methodology, and it serves as the basis for the remediation plan. This is where the regulatory oversight agency has to be involved in this process. So normally what would happen is the lender would pay a contractor to do the site characterization, but then you would need to make sure that the regulatory oversight agency approves the site characterization report. The site characterization report is fundamental for preparing the remediation plan, which is the next step. This talks about the area subject to remediation, the cleanup remedy, the schedule, and provides a firm cost estimate for remediation. As I mentioned earlier, remediation can be very expensive. I mean, even for an underground storage tank, you're talking about possibly $500,000, and then some of the examples we've seen, this remediation cost goes into the millions. So it's important to have a good cost estimate so you can see if the project is actually viable given the remediation cost. Again, the remediation plan requires regulatory oversight agency approval. Normally what happens is that to get the kind of approvals that HUD needs, you need to enroll the developer, and the lender needs to make sure the developer enrolls the project in a state voluntary cleanup program or brownfields program, so the state will give the necessary attention and approvals throughout the whole process. The sixth step is the remedial action itself. I think Stefan alluded to this earlier. There are two types of remedial actions. The first involves complete removal of contaminants. That's where you're removing the contamination to levels below the standards that the state has set. And no further action is needed once those contaminants have been removed. But then there's incomplete removal of contaminants where some of that contamination at levels above regulatory standards will remain on site. The remedial action always requires regulatory oversight approval, and this process has to be completed prior to initial endorsement. In some cases, HUD will allow this to be completed at final endorsement and initial occupancy. So for complete removal of contamination, again, this removes all contaminants below regulatory thresholds. There's no further monitoring or control. Incomplete removal of contamination is called risk-based corrective action, and this allows some contamination to remain on site. The reason we would do that is because of the cleanup costs are infeasible, and there are ways to control exposure to contamination that will actually work. This is not something that we take casually, and it requires justification. And again, this is something that the regulatory oversight agency must be involved in. Risk-based corrective actions can include institutional controls, and the purpose, they really a twofold purpose: to provide notice to current and future owners of on-site contamination, and also to restrict the land use to make sure that the corrective actions that have been put in place aren't disturbed. So the notices can be conveyed through covenants, deeds, and title notices, and the land use restrictions can be conveyed through deed restrictions, easements, zoning regulations, and other land use restrictions, permits, and that type of thing. Risk-based corrective actions can also include engineering controls, and these prevent the remaining contamination that's on site from being accessible to people. So it prevents exposure to the contamination. These can include caps, fences, slurry walls, poured-on vapor barriers, which is what we use for when we have a radon issue, and active and passive venting systems also used for radon. And then the engineering controls also can include monitoring to ensure controls are working. So if you see a monitoring well and some of the contamination information you have, that's an indication that there's contamination on site, and there's monitoring there to see if those controls are intact. And then also associated with any kind of risk-based corrective action, you're going to have operation and maintenance over the long term. Those can include monitoring wells, making sure you have caps and ventilation systems are maintained, You have to make sure that restrictions on groundwater use are maintained and notifications to protect workers and residents to avoid disturbance of the engineering controls. Again, the O&M plan has to be approved by the Regulatory Oversight Agency, and as HUD, and I'm not exactly sure where multifamily does this in the process, but you need to make sure that there's funding in place for maintaining, making sure the O&M plan works out into the future. So finally, for all projects that require remedial action, the Regulatory Oversight Agency needs to issue a written site closure notice, documentation after the remedial action is complete. And this means that the site is safe for its intended use. Because at HUD, we don't have the expertise really to make that determination ourselves. Again, it's the Regulatory Oversight Agency that has to help us with this. And that is how we comply with the site contamination standard, is through the no further action letter when a site has been remediated. This entire process, again, must be obtained prior to initial endorsement and final endorsement, and certainly before initial occupancy. So once you've completed all the remedial action steps and you have your site closure letters, you finalize the review in HEROES before making the firm commitment. I can't stress this enough. This should be done before the firm commitment. And you consider all the studies that you have available. And if the project can't be remediated, or if there's a concern about long-term operation and maintenance of the engineering controls, then you need to think about whether you want to go forward with the project or not. When you complete the environmental review in HEROES, make sure that you append all the supporting documentation. It's really important to include these documents because they're very hard to find if you want to go back later and don't have them. This is the contamination screen in HEROES. And the final step is to convey requirements. Once you've finished with the environmental review, you need to make sure that you carry forward all the requirements of the site contamination evaluation. If there's a risk-based corrective action, you need to make sure the institutional controls are incorporated in closing documentation. For example, the deeds, you need to make sure that the institutional controls are incorporated into the deeds, and make sure that any kind of requirement, engineering controls, long-term monitoring, and financing are included in the environmental review and conveyed to the borrower. Failure to convey these requirements can really leave HUD in a vulnerable position. Multifamily Housing has produced this really great brochure on site contamination, choosing an environmentally safe site, and it's online at these links. So with that,
over to me.
Yes.
And I will just briefly mention that if you are looking at contamination and there's an O&M plan with costs involved, those costs may not be in any historical records, but typically it would be handled by the appraiser who's looking at the expense analysis. Perhaps an underwriter will be undertaking that as well, but you would want to make sure that going forward it's allocated in the expenses so that it affects NOI and our collateral.
So it looks like we do have a couple of questions, Barbara, for you on the contamination. It looks like, who is the responsible party for cleanup cost? The current owner at the time of the contamination was discovered, or the previous owner who caused the contamination?
It can be both. It can be present owners, past owners, and even if you're a past owner and you didn't cause the contamination, or you're a present owner and you didn't cause the contamination, you can still be held liable for cleanup cost under Superfund.
One of the big purposes of the Phase 1 environmental site assessment is to provide the new owner with the innocent landowner liability protections. And so as long as your due diligence has been done prior to purchasing of the property, then you would not be held responsible if it is later found to be contaminated. Okay, we have another question. It says, could you repeat again the distinction between an environmental site assessment, the Phase 1, and an environmental assessment?
The phase one is phase one environmental site assessment. That's the same thing. So phase one environmental site assessment is an ASTM phase one, and it's used only for evaluating HUD's site contamination policy. An environmental assessment we're going to go in later. That's a NEPA review, and it's different.
I'll just add one clarification to that. Site contamination is just one aspect of the laws and authorities at 50.4. The 16 laws and authorities that we have to comply with at 50.4. And one of the ways of doing that is this phase one environmental site assessment. The environmental assessment, the full environmental assessment, is all 16 of those laws and authorities at 50.4 plus the environmental assessment factors we're going to talk about tomorrow. And together they can combine to make the environmental assessment. Phase one environmental site assessment is just answering one question of the 16, and that's the site contamination questions. Okay, no more questions.
Moving right along, we get to lead-based paint and our overview. We've actually combined this with our asbestos slides as well, so that everything flows better. Basically, lead-based paint was outlawed in the 1970s, so we're always concerned with pre-1978 structures. Our standard is 24 CFR Part 35. Again, I'm going to circle back around. The purpose, again, is HUD-insured projects shall not place occupants, especially children, in harm's way of lead-based paint hazards that are associated with a wide range of adverse health and behavioral problems. So we'll go right back to protecting the residents. Potential triggers. The hazards must be addressed for conversion, minor and major rehab activities pertaining to multifamily residential buildings constructed prior to 1978. We have a slightly different definition. A major or sub-rehab is defined as rehabilitation work that is estimated to cost greater than 50% of the estimated replacement cost after rehab. I will also mention that adverse health problems include autism, stunted physical growth, brain and liver damage, and there are behavioral problems as well. Typical exposure pathways are ingesting and digesting or breathing in airborne lead particles or dust that will enter the bloodstream. Circling back around, we have more discussion about pre-78 structures. The following criteria are exceptions to Part 35. The project is proposed for demolition, provided the property will remain unoccupied until demolition. And I'll take this opportunity to mention that this is demolition that's generally non-mortgageable, where you're demolishing the building to get to the vacant land. We're not talking about minor demolition, demolishing a wall in a sub-rehab. Another exception is the housing is designed or designated exclusively for elderly or persons with disabilities, unless a child of less than 6 years of age resides or is expected to reside there. So if you're out there looking at refinance of a 202, it's always be careful to ask for whether there's a child of 6 years of age who is residing there. It's not something that people like to talk about, but as soon as you see it, it throws a red flag. Zero-bedroom dwelling units, also known as studios or efficiencies, if the entire project is made up exclusively of zero-bedroom dwelling units, and applications for insurance in connection with refinancing transactions where HUD's procedures do not require an appraisal. In other words, are categorically excluded 223A7s. I'll also mention, because we talked about it, abatement equals removal or replacement, and encapsulation enclosure with HUD-approved exceptions. And some of these exceptions also are architectural in nature or historic preservation. Takeaway here, we look at things a little bit differently for pre-1960 buildings. We have to use a risk assessor to prepare a risk assessment report that identifies lead-based paint hazards. We can deal with it if we find any. They can be treated with interim controls. Interim generally should be completed prior to the firm commitment or issuance of the firm commitment, but may be completed prior to final closing with HUD approval. Obviously, they're making a case, and it's up to us to concur or decide that it doesn't make sense. Applicants shall incorporate ongoing lead-based paint maintenance procedures into regular building operations. Another word for an O&M plan if you've encapsulated the lead-based paint. Interim controls I have as an example: cleaning surfaces to remove dust. Paint stabilization shall include the application of a new protective coating or paint. That's going to encapsulate it. Repair poor surfaces, high impact friction surfaces, windows, doors, and cornered surfaces. Lead-based paint maintenance monitoring must include a HUD-approved O&M plan for which units and lead paint are visually inspected at least once a year per specific guidelines. And tenants and occupants must be educated about the lead-based paint risks. Moving to the next slide. Here we're getting into multifamily buildings with conversion or major rehab, so we're talking basically 221D4. Here you're getting a state-certified lead-based paint inspector, and they will perform a lead-based paint inspection to identify the presence of lead-based paint in accordance with our 24 CFR Part 35. I'm not going to read all the rest. If lead-based paint is identified here, the firm commitment shall require abatement in accordance with the regs to be completed prior to initial occupancy and final closing. Again, here, generally, abatement is achieved through paint removal or component replacement. We can, at our discretion, approve a permanent encapsulation or enclosure and incorporate into the ongoing lead-based paint maintenance. If the removal and component replacements are not practicable, again, start thinking historical or architectural concerns. I have written in my notes that paint removal by wet scraping, wet sanding, some sort of a stripper remover for non-fixture objects, and generally done with a HEPA-filtered local exhaust attachment. Quick picture. We've all seen this in older homes. Most of us probably grew up with it. Hopefully none of us were eating it. The health effects when lead enters the body through dust in the air or eating paint chips. Lead's heavy metal toxins target the brain and nervous system. As an effect, there can be adverse hyperactive behavioral and learning disabilities, and it compromises body growth. In Flint, and I guess we're talking Flint, Michigan, 5-year-old twins, one is 50 pounds heavier after 1 year and the other is only 5. We take these considerations very seriously. Lessors or owners must comply with the lead disclosure rule. Anybody who's ever bought a single-family home has had to go through that with your local broker, realtor. The cost of abatement or hazard control work may be included in the proposed mortgage loan with HUD approval. So it is a mortgageable cost. Moving on to asbestos, handled again in Chapter 9, Section 9.5. This is B. State agencies license contractors for proper asbestos abatement procedures in accordance with OSHA and ASTM standards. The purpose, asbestos-containing building materials must be removed, and Stefan talked about this morning, must be, not shall, but must be removed for most HUD-insured projects to protect the health and safety of occupants and not conflict with the intended utilization of the property. Here we get potential triggers. You're likely to see this in HUD-insured demolition and rehab projects. Asbestos itself is a naturally occurring mineral widely used in building materials and commonly appears in home and piping insulation or wrapping. So when you're down in the maintenance areas or the boiler room, this is what you're going to be looking at. And if you do see some, ask the maintenance people if it's asbestos, if it's been identified as asbestos. Very often these days it's made up of some sort of matting material, fiberglass in nature. You'll also see it in vinyl floor tiles and the surface of tiles and their adhesives known as the mastics, glue or wallboard, and again in the joint compounds there, siding and cement roofing shingles, and sprayed on surfaces of building frames. Those sprayed on surfaces, start thinking World Trade Center, where they blew it in with huge hoses before encapsulating. Intact and undisturbed asbestos building materials do not pose a health risk. Asbestos fibers can be released into the air when it is damaged, disturbed, or deteriorates over time. So we're always mindful it may start off as a floor tile with anything more than 1% asbestos in it, but somebody's using it to repair something with a hammer and it starts to chip, crack, fracture. It's going to release some of those fibers in the air and they get caught in the lungs. Various visual examples of asbestos. You can see in the upper left pipe wrapping because it insulates against heat and cold. Microscopic view on the upper right of asbestos fibers. That's what gets caught in the linings of the lung. The body can't absorb it, can't get rid of it, so it tends to encapsulate it in and of itself with scar tissue, and that scar tissue later on can become cancerous. You can see ceiling tiles on the lower left, and on the lower right you see some damaged floor tiles. And there are times when you will see something like this, or it's been overlain with linoleum, and that's the encapsulation for floor tiles underneath. I used to deal with a lot of floor tiles when I was working on the 811 program, and it was amazing that people would rather have an O&M plan for $1,500 to $2,500 rather than taking out 50 square feet of floor tiles for $500. It just didn't make sense to me. We get into the health impacts. Asbestos fibers are small, weightless, strong, and fire retardant. May remain in the air for many hours after they are released from asbestos-containing building materials. And again, we get into asbestosis or mesothelioma. We're talking about forms of cancer. Unregulated building demolition is a major source of asbestos-containing materials. I live in New York. I'm walking on the sidewalk. I can smell building demolition, and I'm wondering what I'm inhaling. And sometimes I just wish I had an air filter in place. For any structure built before 1978 to be demolished, completely demolished, a comprehensive building asbestos survey is required. The survey has to be performed by a qualified asbestos inspector. It's pursuant to the pre-construction survey requirements of ASTM E 2356-10, Standard Practice for Comprehensive Asbestos Building Surveys. You'll notice that 2356 is the number, 10 means that it's been around since 2010. So if we, in the next couple of years, come up with an updated standard, don't just refer to this in the MAP guide. We always work off of the most current standard. For structures built before 1978 to be rehabbed, an asbestos survey is required pursuant to the baseline survey requirements of that same ASTM requirement. In this case, it's less intrusive. You're not breaking down walls to get to things, so you have a level of risk. You have suspected asbestos is found. You can test it, and if you don't test it, you have to presume that it is asbestos, and without confirmatory testing, it's treated just as if it is, and it shows up in the O&M plan. They make no real difference. If it gets surveyed later on and it is, then your due diligence is complete because you're not overreacting. You're taking prudent precautions. So Here's our chart. Structure built prior to 1978. Yes, it's the proposed project, and if it's for demolition, you need the comprehensive building survey. If it's for rehab, you need the baseline asbestos survey requirements. And you're either going to assume that it is asbestos or you require that it be confirmed through testing. Now we get into some definitions. For rehab projects, friable or damaged asbestos must be removed. In 2011 of the MAP guide, that was only recommended. I'll give you a working definition. Friable asbestos-containing building materials can be pulverized or crumbled by mere hand pressure that, when disturbed, can release toxic fibers into the air. Asbestos, if the asbestos is not friable or damaged, HUD strongly recommends that it be encapsulated and incorporated into an O&M plan. I would much rather, if it's in de minimis levels, I'd rather see it removed. And as I mentioned before in that example, take a look at the costs versus the risks. You may feel that it's better to remove it and not ever have to worry about it again. You get a certification that it's been removed and you've taken care of that liability. The O&M plan will inspect periodically and properly abate when required. Asbestos abatement is dismantle or remove, encapsulate, close, or repair. MAP guide and timing requirements. An asbestos survey must be submitted with the application for a firm commitment as part of the environmental review or tailored phase 1. Tailored meaning when the environmental report, is incorporated into the phase 1. Again, the survey, if that survey identifies asbestos or asbestos is assumed, HUD will special condition the firm commitment on an appropriate mix of asbestos abatement and an O&M plan. Unless structures will be completely demolished, the cost of any asbestos abatement may be included in the proposed mortgage loan. So circling back on that, we don't pay for demolition costs, so we wouldn't pay for asbestos removal on a building to be demolished. Some quick takeaways. An ASTM certifiable pre-construction asbestos survey report is a requirement for demolition projects for buildings older than 1978. An ASTM certified baseline asbestos survey report is required for rehab projects for buildings older than 1978, and a survey must be made part of the environmental report or a tailored phase 1. If abatement is required, the firm shall so condition. This survey is a requirement for all multifamily programs except for the 223A7. And I have an asterisk unless there's minor repair, rehab, or an O&M plan does not exist. And I'm wondering if that's a typo since I inherited this slide. Get ready for a screen shock. Ouch. HUD doesn't really have a mold policy. Certainly it's not written in the MAP guide, but we know what mold is. We know that it causes respiratory illness problems with infants and elderly. It's certainly toxic. We certainly see the after effects of it with sick building syndrome. And from a structural perspective, we know that mold thrives in a wet environment, so very likely there's some sort of water intrusion. Anytime you get water coming into the building, into the envelope, you've got other problems as well. So this could be a harbinger. It may not be as obvious as that. Probably if I saw that, I'd be running. And I would certainly want the lender to go in there first and sample it all he wants. But at that point, because of the water intrusion, I would also be talking to my cost analyst or architect about whether it's showing up in the critical and non-critical repairs. And that finishes my presentation on this. We're coming back to Barbara Britton, who's going to be handling explosive and flammable operations. Barbara, you all set? Here's your clicker.
Keep the questions coming also, and we will, there are questions for Rick.
We have questions already. Not shy. Charming. Who is responsible for liability, the agency or the HUD housing team member? I think I would send this over to one of our lawyers. I don't really know what our personal liability is, acting on behalf of the government and trying to provide safeguards for the public and the residents. So if we can put that question aside,
We'll hold that one.
we will get back to you on it. Are there any other questions? Can we include lead-based paint inspections in the annual inspection in the regulatory agreement? Ooh, these are underwriter questions. I'm an appraiser by training, so I'm going to punt on this one as well. Perhaps Dan can answer it. Dan, who has forgotten more about our regulatory agreement than I'll ever know. We'll get back to you on that as well. Other questions?
Rick,
Sure.
Rick,
Yes.
let me weigh in on the question about O&M plans for lead-based paint or asbestos. Those should be included in the management documents, not in the regulatory agreement typically. We would expect the O&M plan as a condition of the firm. It's part of their due diligence and their commitment. We are concerned with, however, them just printing out boilerplate forms to get their mortgage insurance, and then they never remember it again. So I do think it's important that in their management documents for the property manager that O&M plan be specifically referenced, and that's how we would normally see it.
Okay.
With respect to the other question about liability, it matters that I'm not a lawyer, and so we're not going to answer that definitively. I will observe, however, that HUD has been sued over environmental issues at great cost. The nice thing is it hardly ever happens. When it does happen, it's dramatic. In my experience and to my knowledge, no HUD employee has ever been individually held responsible. On the other hand, as a point of negligence, you would not want to be the first to test that legal theory. So basically why we're giving this training is so that you can avoid such incidents.
I think I saw another question popping up. Nope, no further questions. Okay. Barbara, back to you on explosives and flammable operations.
All right. Explosive and flammable operations are part of HUD's Part 51 standards and criteria under Subpart C, and they're also covered under MAP Chapter 9, 9.5.1. This is an illustration of a tank exploding near low-income housing. These types of situations result in harm, always end up in the press, and can be very devastating. The purpose of our explosive and flammable hazards review is to minimize risk from any kind of above-ground storage tank that could result in an explosion or fire and put people in harm's way. Our standard is that HUD will not insure property where residents are an unacceptable risk due to proximity to above-ground storage tanks with these types of hazards without the proper mitigation. All new construction, this applies to all new construction, rehab, or conversion that will increase residential exposure. The MAP guide itself requires consideration of these types of impacts for all of its projects. In defining what the hazards are, we're really looking at any stationary container which stores, handles, or processes hazardous substances that are prone to explosion or fire. And the substances that we're talking about are petroleum products and chemicals that can produce blast overpressure and thermal radiation and levels that exceed our safety standards. And we have safety standards for explosion risk that applies to both people and buildings, and thermal radiation from fire that applies to people. The thermal radiation, we're all familiar with what types of impacts explosions can cause. Thermal radiation, actually when I came to HUD, I was a little bit surprised to find out about this, but fires from above ground storage tanks can result in such high heat that it can result in third-degree burns to people nearby within a matter of minutes. So it's a very dangerous situation when these things occur. This is the list of hazardous liquids that the regulations cover. If you identify a tank as part of your review and you want to know if its contents are subject to the regulation, you need to refer to the appendix in subpart C to see what hazardous liquids are covered. And this is a list of hazardous gases that are covered. What we do at HUD to determine whether where the safe area is within proximity to above ground storage tanks is we determine the distance beyond which the explosion or fire hazard is not likely to cause impacts to structures or individuals. And so we call this the acceptable separation distance. So as you can see in this diagram, the distance from the, you have to calculate the distance from the above ground storage tank and calculate the acceptable separation distance and make sure that the property's outside that distance. Otherwise, if it's not, it's in the danger zone. And the people and the structures there could be in harm's way. There are 5 steps to evaluating these kinds of hazards. First, you need to determine if you've got the kind of project that the regulations apply to. And then you determine if they're above ground storage tanks within a 1-mile radius of the property. If you find that there are above ground storage tanks, you need to collect data on any of the above ground storage tanks within that radius. The 4th step is to calculate the acceptable separation distance. And then the 5th step is to determine whether the project's in compliance by comparing the acceptable separation distance to the distance from the tank in question to the property, and we'll review the content of each of those steps. So to determine if the regulation applies to your project, this regulation applies to new construction of multifamily housing, any project that increases residential density through rehab, if you're converting a non-residential building to residential for residential purposes, or if you're making a vacant building habitable, then the regulations would apply. In addition, if your project involves installing above ground storage tank where they previously didn't exist in a residential area, you need to consider that subject to the regulations. What we're trying to do is protect people not only within the homes but in outside areas as well. We're concerned about children on playgrounds, people making use of outdoor recreation areas such as parks and open space. We want to protect people that are outside on their balconies and in the parking lots of the buildings. The regulation doesn't apply to pipelines that are flammable and explosive if they're located underground or if they comply with applicable state, federal, and local safety standards. They don't apply to tanks that are 100 gallons or less that contain common liquid industrial uses. Make note, this is liquid fuels. They don't apply to mobile conveyances, underground containers, or natural gas holders with floating tops. So if your project it involves any of these things, then you don't need to comply further with this regulation. So the second step is if your project is the type of project where consideration of explosive and flammable hazards is required, you need to determine if there are above ground storage tanks within a mile of your property. A lot of times the Phase 1 environmental site assessment will identify above ground storage tanks. You can look on Google Earth. That's what I've used a lot since, a lot of times I'm doing a desk review of a project site. You need to drive around the area yourself when you're doing your HUD site visit to make sure there aren't any above ground storage tanks, and if you look at this picture on the right, it looks kind of normal, and then you look in the back and you see two big crude oil storage tanks in the background. That's the kind of thing you need to keep your eyes open for. And then one of the best places to get information about storage tanks are the state databases. I don't think every state has this, but many do, and they're usually very good sources of information about above ground storage tanks. If you do find that your project is within a mile of an above ground storage tank, you need to find out more about the tanks. You need to find out their size, what's in them, whether what's in them is a liquid or a gas, whether they're under pressure or not, and whether they have a dike. If they do have a dike, then you need to know the dike dimensions, because you'll need all of this to be able to calculate the acceptable separation distance. One of the best data sources is to go to the company that owns the tanks. They're usually very happy to help and give you the information. The fire department or hazmat organizations can provide the information. The planning department and the phase ones can also provide some information. You also need to determine whether the tanks are under pressure or not under pressure. This makes a big difference in the way we consider the acceptable separation distance. If tanks are under pressure, then we consider both the explosive and thermal hazards. If they're not under pressure, we're just looking at the thermal radiation hazard. This is an example of a dike. And what happens is if there's an explosion or for some reason the liquid is released, the dike will contain the material. Having a dike tank can really reduce the ASD quite a bit. So if you've got your tank identified, you know how far it is, you know what the contents and all the parameters are of the tank itself, then you need to determine the acceptable separation distance for that site. We have an ASD assessment tool on our HUD exchange, and once you've got all the information, all you have to do is plug it into our tool. You would include whether the tank is above ground, whether it's under pressure, if it's diked, and if it's diked, what the dimensions are. And then it automatically calculates the ASD for you. And what we do in looking at the acceptable separation distance, because there are two standards, one for explosion and one for thermal, we use the greater distance to determine compliance. If the distance to the project, when we're determining compliance, what we're looking for is once we've completed the acceptable separation distance, we want to make sure that the distance from the nearest tank to the project perimeter is greater than that distance. If it's not, then the project is located in the danger zone. And certainly in these cases, the technical support folks are really need to be involved in this type of scenario. And really, you have two choices when you're dealing with a project that's within in the danger zone for an above-ground storage tank, and that is to reject the project or find a mitigation measure that will prevent the risk. What we need for the environmental review record, these are the documents that you'll be uploading into HEROES, is some sort of written documentation to show the presence or absence of tanks within 1 mile of the project. If you have a tank that's within 1 mile of the project, then you need to include your ASD calculation and the data that you use to make the calculations. We always like to see a Google Earth map with the distance from the center of the nearest tank to the project perimeter noted on that map. And so we can either show that there aren't, the project is or is not within the ASD. If there is a mitigation required, you need to include the engineering report. And as we stated before, you need to make sure that if there's any mitigation required for this type of impact, that is well documented and conveys further into the environmental review documentation as well as the closing documentation. HUD has a really great guidebook, citing of HUD-assisted projects near hazardous facilities. You can find that on the HUD Exchange at this link. It really, really has all the details on all the science behind the standard that we have. So I think that's it.
All right, we'll wait and see if we have any questions here real quick. And if we don't, then we will go straight to Nancy on historic preservation. But feel free to send us questions whenever you have them, and the powers that be behind the cameras will stop us and let us know.
There's a question.
Okay. Should the Phase 1 report have a specific section titled Environmental Report? The lender says it's part of the general report, but there's nothing really separate like 1 or 2 paragraphs. I'll just take this real quick, and then you can add something, Rick, also to it, or Barbara as well. What we usually see in the Phase 1s is the table of contents for the Phase 1, and then you'll see a section after the main portion of the Phase 1 titled Out-of-Scope Services. And it's in those out-of-scope services that they will address all of the issues that are not part of the Phase 1 environmental site assessment: wetlands, endangered species, floodplain management, things like that. So that out-of-scope services is what we're also considering the environmental report, which is the information besides the contamination that comes in the Phase 1 environmental site assessment. Do you have anything to add to that one as well, or you think I covered that?
I think you covered it pretty well. It's in the Phase 1, whether it's deeply buried or right at the right after the recs and vecs remains to be seen. If it's not in the table of contents and you have to go digging into 1,000 pages, it can be sometimes a little bit more difficult. Sure.
One of the things when I'm reviewing Phase 1s, especially it's almost always for multifamily projects, I find it really difficult when the Phase 1 aspect of the report is mixed in with some of the other laws and authorities for the environmental review, like floodplains and wetlands. The ASTM is really specific on what the requirements are for a Phase 1, and it kind of muddies the water if they incorporate the NEPA requirements in the Phase 1 content itself. So it's always better to separate the Phase 1 from the contents of the environmental report.
Mm-hmm. And we tend to see them written into the body of the report, but after we get to the findings, opinions, and conclusions section, very often they'll then deal with out-of-scope issues and come up with their recommendations. And then again, it's up to us to decide whether we concur or whether we disagree and want further information. If there are no further questions, we're going to take our 15-minute break now, kind of get up and stretch our legs, and we'll see you back.
And when we come back, then we will go to historic preservation with Nancy. We're going to take our break a little early.
Yes, we'll be back at 3. Thank you.